ये गैप क्यों हो रहा है? आने दीजिए, आइए।
May I come in, sir?
Yes, yes.
Good evening, sir. Good evening, ma'am.
Sit down, sit down.
Thank you, sir.
Why did your marks become lower in class 12 compared to your class 10 marks?
Sir, actually, I have opted for commerce and mathematics, but I didn't able to score much in mathematics. I scored only 50 marks in mathematics at that
that's
time.
quite the average.
That's why my
That's quite the
aggregate went very low.
So mathematics is basically by practice.
Scoring subject.
Yeah, it's by practice.
Sir, actually, I am not that much interested in mathematics,
Oh,
but
that is
my
the problem.
father wanted me to opt
Your
as an.
father is a smart man. Because mathematics is very good.
Yes,
What does
sir.
the father do?
Sir, my father is in Rajasthan Account Service.
Yeah, so he understands the importance of mathematics.
Yes, sir. Yes, sir.
He understands. So you went to University of Rajasthan?
Yes, sir, for my graduation.
This is 3-year course, 5-year course.
5 years, sir.
5 years?
Yes, sir.
So what made you choose law? Because you couldn't do mathematics, you said let's become a lawyer.
No, sir. Actually, since the starting, I want to join the service where I could contribute my little towards the society of people, and I find that judiciary is the best option. That's why I chose law as a graduation.
How does judiciary contribute to society?
Sir, judiciary is the sole institution where common man reach with his last hope to get the justice. So,
Justice, but with so many delays in courts, where's the justice? I think it's more about employment, because the fact of the matter is, anyways, so it's a good thing. So, what's the best part of being a judge? What's the best part of being a judge? Don't tell me about service to society. Everybody does service to society. Even a guy, a poor man who cleans the sewerage, that's to the society. Because you and I cannot live until the sewers are cleaned, until the roads are swept. So everybody who's working is doing service to society. So there is nothing extraordinary about the contributing to society through the judiciary. Anyways, so what's your favorite subject in law?
sir, I have given equally importance to all the subjects that are covered under the syllabus of this exam.
Okay. Which is of the civil law? Which is of
ये आर्ट ऑफ क्रॉस एग्जामिनेशन आपका पेपर होता है, इसमें क्या है?
Sir, cross examination was the subject in our last semester. Cross examination means examination of witness by an adverse party is cross examination. It is given under section 137 of Indian Evidence Act.
What is the art? आर्ट क्या है क्रॉस एग्जामिनेशन?
Sir, art of advocate is required in conducting good cross examination of any witness. So,
क्या आर्ट?
वो क्या खास बात है? What makes a good cross examiner?
विटनेस से झूठे गवाह से कैसे निकालेगा?
by impeaching his credit.
ये तो ठीक है। So, impeaching is credit and all that. This is the net result of that.
Yes, sir.
But what is the art? You can say it's आप उसको ऐसे कह सकते हैं कि ये आर्ट जो है वो प्रैक्टिस से ही आती है
Yes, sir.
कि हम उसको कैसे करेंगे। लेकिन आपको पहले विटनेस को समझना होगा, उस केस के फैक्ट्स को समझना होगा, उस केस में इन्वॉल्व लॉ को समझना होगा। Then only you can do the good cross examination.
Yes, sir. And sir, putting questions is in a particular way is also very important so that truth can be
और
extracted.
आपको उससे ऐसा कोई सवाल नहीं पूछना होगा जो वो आपके खिलाफ जवाब दे दे।
Yes, sir.
Means the question which have been put by you are so framed so that witness should give reply in your favor only.
Yes, sir.
So वो जो आर्ट है वो प्रैक्टिस है।
Yes, sir.
एक एक्यूज आता है, उसने मर्डर किया, ये सबके पास आता है, आप जाओ, ये सब कोर्ट में जाते हैं, सर इसने मेरे साथ में कन्फेशन किया, तो एक्यूज का स्टेटमेंट बिफोर हिज एडवोकेट, क्या वो एफिशिएंट होगा?
Sir, as far as my limited knowledge is concerned, that communication will be protected under Section 126 of Indian Evidence Act.
Yes.
Please communication.
Yes,
Student
sir.
communication.
Yes, sir.
तो एडवोकेट को अपने एडवोकेट को तो खुद बताना ही होगा,
Yes, sir.
एंड दैट इज कम्स इन प्रिविलेज।
Privileged communication. Yes, sir.
वो एक्यूज की एविडेंस का क्या महत्व है?
Evidence of accused.
Co-accused.
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 Sir, if any evidence is given by the co-accused, then it can be used as an evidence against all the accused if they are trying in the joint trial for the same offence.
क्या उसकी एविडेंस पर उसका कन्विक्शन किया जा सकता है?
Accused की evidence.
Co-accused.
Co-accused.
Sir, I'm not able to recall it right now. I have to look into it.
Section
आपका
133,
कॉमन
130,
सेंस क्या कहता
114,
है?
illustration.
आपका कॉमन सेंस क्या कहता है? क्या कर देना चाहिए? कॉमन सेंस, चलो, लॉ इज नथिंग बट इट इज कॉमन सेंस। आपका कॉमन सेंस क्या कहता है?
सर कर सकता है।
But if it is inculpatory, you know what is inculpatory? If it is inculpatory or it is exculpatory,
अपने आप को बचा रहा है।
yeah. So what is the difference between the evidence of an co-accused if it is inculpatory, and what is the difference when it is exculpatory?
Sir, the concept of inculpatory and exculpatory evidence is ruled out in case of Pakala Narayan Swamy versus Emperor, but sir, right now I'm not able to recall the exact meaning.
What do you mean by inculpatory and exculpatory?
Sir, I have to read on it.
Inculpatory means when the accused says, I did it. And exculpatory, he says, I was not there, he was there.
Hmm.
The inculpatory is the direct accusation on himself, direct confession.
Yes, sir.
And what is the status of the evidence of an approver?
Sir, of an approver.
Yes.
Sir, approver is a competent witness. So, on his evidence, conviction can be done.
Can be done.
Yes, under Section 133 of Indian Evidence Act.
On his sole evidence?
Yes, sir. There is no particular rule which says that there cannot be a sole conviction on the evidence of an accomplice. It can be done.
Approver. I didn't talk about accomplice. I said an approver.
Which
Who's an approver?
Sir, accomplice when gets tender of pardon becomes approver.
The witness.
Yes,
Yeah,
sir.
Fair enough. So
He's
an
a competent
accused, when an
witness.
accused becomes a witness, right?
Dying declaration का क्या प्रिंसिपल है? क्या उसी के आधार पर कन्विक्शन किया जा सकता है?
Yes, sir. In the various precedents of Honorable Supreme Court, like Kushal Rao versus State of Maharashtra, Kalavati versus State of Maharashtra, it was held by Honorable Supreme Court that dying declaration can be a sole basis for conviction.
उसकी क्या टेस्टिमनी होनी चाहिए dying declaration?
Sir, it should be made voluntarily, without any inducement, threat, or promise. It should be freely made by the person who has died or whose death has been done. And sir, it is made before the reliable person.
How we check whether this dying declaration is made freely without intimidation? How would judge?
Sir, generally dying declarations are recorded by magistrates. Generally dying declarations are recorded by magistrates, and sometimes circumstances might happen in which dying declarations are being recorded by police officers also, doctors also. And sir, on dying declaration there is thumb impression or signature of the declarant also. So from that we can judge that it is made.
One more point is there. Is the state of mind at the time of the main declaration.
And
Yes.
medical condition.
Medical condition and his position, rather, at that time she was in a position to give that statement.
Activity understanding of the things. Not missing.
Yes, sir. Okay.
डॉवरी के केसेस में बहुत सारे जगह देखा गया है कि जो मरने वाली महिलाएं थीं उन्होंने ये कहा कि मेरी ननद ने, मेरे हस्बैंड ने आग लगा के मुझे मारा है, और सिर्फ इसलिए कहा कि मैं तो मरी रही हूँ, इन्हें भी डुबा देती हूँ। तो क्या डैन डिक्लेरेशन एक अच्छा एविडेंस है, स्ट्रॉन्ग एविडेंस है, या एक वीक एविडेंस है?
Sir, in my opinion, if it is made voluntarily and on the facts, on the real facts, so it cannot be considered as a weak evidence. We need to be very cautious while convicting on the basis of soul dying declaration, and it is the duty of the court to point out the chef from the grand. So we need to be very, very careful while convicting the accused on the sole basis of dying declaration, but it can be done on the sole basis of dying declaration. There is no rule that conviction cannot be.
You are saying it is strong evidence?
Sir, I am saying that if it is taking, if it is considering with due care and caution, then it is definitely not a weak evidence. It can be considered as a good evidence.
It's a matter of appreciation of evidence.
Yes, sir.
It's a matter of appreciation, basically.
Yes, sir.
Basically.
डाइंग डिक्लेरेशन लेते समय क्या जो डाइंग डिक्लेरेशन दे रहा है उसके रिलेटिव्स वहाँ खड़े हैं, तो ऐसा होना चाहिए या नहीं होना चाहिए?
सर, वो कंडीशन पे डिपेंड करता है कि डाइंग डिक्लेरेशन देने वाला किस मेडिकल कंडीशन में है उस टाइम. अगर वो
कंडीशन
सर उससे कोई फ़र्क नहीं पड़ना चाहिए. अगर डाइंग डिक्लेरेशन रिकॉर्ड ऑथेंटिक पर्सन कर रहा है, फॉर एग्जाम्पल सर
एक व्यक्ति डाइंग डिक्लेरेशन कर रहा है, उसके सामने उसके रिलेटिव
ट्यूटरिंग हो रही है पर
तो क्या वो खुदनेस आ पाएगी?
सर, मेरा ये मानना है कि मरते वक्त आदमी कभी भी झूठ नहीं बोलता.
That's the presumption of law.
इसे सैद्धांतिक बात है।
सैद्धांतिक बात है।
Yes.
पर ये भी तो हो सकता है ना कि अगर घर वाले सारे खड़े हैं तो उसको जो कहना था वो नहीं
You
कह के
should
वो
appreciation. That is appreciation of evidence. You know what that. Then one thing I must say, is it necessary that a person who makes a statement should be under imminent likelihood of death for it to be considered as a dying declaration? Or any last statement can become a dying declaration. Somebody is having a cup of tea with somebody, a friend of his, he tells him something, and on the road he goes and he dies in a car accident. Will it be a dying declaration? Is every statement immediately before death a dying declaration, or is it necessary that for a dying declaration, for a statement to be treated as a dying declaration, it should be under imminent fear of death?
Sir, it is presumed that if the statement is related to the cause of his death or any of the circumstances which led to his death, such statements are considered
Only those
as.
statements.
Yes, sir.
Not the last statement.
Yes, sir.
Fair enough. Fair enough.
What is the difference between insaneness or unsoundness?
Ma'am, unsoundness of mind, section 84 of IPC talks about unsoundness of mind. If the person is unable to understand the nature and consequence of the act, that is unsoundness of mind. He is not in that mental state of mind which requires to understand the real nature and circumstances of that is. Or insanity may be legal insanity or medical insanity. So.
Okay, beta. Thank you very much. Good.